Welcome to EUPrivacyForAll, Session 64 on GDPR, Procedure and Confidentiality of the EDPB, Articles 68 and 70. European Parliament suggested that Article 68 on the procedure in EDPB would mention that a simple majority is needed to take decisions unless otherwise provided in its rules of procedure. In Article 72, it stressed that where necessary and unless otherwise provided in its rules of procedure, once again, the discussions of the EDPB may be confidential. The proposal that the agendas of the EDPB shall be made public was not let down in the final draft. On its side, EU Council suggested that the EDPB shall adopt binding decisions with majority requirements framed by a simple majority. The two-thirds majority would be framed in paragraph 2. In Article 72 on confidentiality, access to documents submitted to members of the EDPB was to be framed by the regulation proposed by EU Commission. In the final draft of Article 68 on the procedure within EDPB, the European Data Protection Board shall take decisions by a simple majority of its members, unless otherwise provided for in this regulation, and we'll see there are only two cases. The EDPB shall adopt its own rules of procedure by a two-thirds majority. This is the first exception. In Article 72 on confidentiality, with regard to EDPB, it is stressed that the discussions of the board shall be confidential where the board deems it is necessary, as provided in its rules of procedure voted by a two-thirds majority. Access to documents submitted to the board shall be governed by the regulation adopted in 2001 regarding public access to European Parliament, Council and Commission documents. Currently, Article 29 of the Directive on the Working Party stresses that the principle is the same. It is a vote by a simple majority. The Working Party shall adopt its own rules of procedure. In Article 28 on supervisory authority, Member States are framed in order to provide that members and staff of the supervisory authorities are to be subject to a duty of professional secrecy with regard to the confidential information to which they have access. This is the only referral to confidentiality. What should accountable data controllers and processors get prepared for? First, knowing that on the principle, the EDPB will take decisions by a simple majority of its members, unless it is otherwise provided for in the GDPR. There are two cases in which decisions should be taken by a two-thirds majority. The dispute resolution mechanism referred to in Article 58A and the adoption by the EDPB of its own rules of procedure. The EDPB is also supposed to be organizing its own operational arrangements and laying down in its rules of procedure voted by a two-thirds majority which discussions of the board shall be considered as confidential. Access to documents that are submitted to the EDPB will be subject to the regulation adopted in 2001 regarding public access to European Parliament, Council and Commission documents. Two questions could be triggered today. What does mean organize its own operational arrangements? And will the simple or two-thirds majority vote allow the EDPB to monitor swiftly and consistently data protection across EU?